Welcome, and thank you so much for joining today's webinar, Practical Antitrust Advice for Health System Leaders in 2023. I'm Kristen McDermott Woodrum, a partner in the Healthcare Department of McGuireWoods. I'm based in Atlanta, but work closely with our national healthcare team and clients across the country, and I'm thrilled to be joined today. A clinically integrated network or other matter, antitrust is always a key consideration. And over the years, I think a lot of us on the healthcare side have gotten fairly comfortable issue spotting, knowing when to bring in an antitrust specialist, and counseling clients on the general parameters of what works. But recently, just in the past couple of years, it feels like everything has changed. And as we'll hear, that's because all around us, antitrust policy and enforcement is changing. Today, we'll start with a very quick intro to set the stage on what's happening with healthcare systems, where antitrust could focus. Then we'll spend some time with 11 antitrust developments to know. While this doesn't cover everything, these are important topics that you've probably heard something about. They can impact your operations, transactions, and strategic planning. Our partner, Scott Becker, frequently publishes lists on Becker's Healthcare that are consistently oddball numbers, so we felt okay going with 11. And we'll wrap up today with a few takeaways and key lessons. If you have questions, please insert them into the chat box. We'll be tracking them. Since we have so much to cover, we may not be able to address all questions today, but we will track them, and we'll be happy to get back with you with answers. So now to kick things off. Healthcare plus antitrust. So much fun and so much to talk about. Holden will talk more about antitrust enforcement, successful or not, but I was struck by this statistic. Healthcare comprises approximately 1/6, maybe a fifth of our US economy, but represents about half of all US federal antitrust enforcement. So hospitals may feel like a target, and we've seen some tough times for hospitals here in the past few years. Expenses are up, margins are down, care is shifting away from the inpatient setting to outpatient sites. We're seeing new entrants and competitors and a huge push for price neutrality. And on top of all that, healthcare systems have unique antitrust issues. They occupy a unique position in the healthcare landscape. Hospitals have a large footprint, which is market share, and have a presence at many different levels in the market: acute care, outpatient, specialties, and this introduces vertical issues. And health systems are also drivers of collaboration, clinically integrated networks, accountable care organizations, different PSAs and JVs, all these collaborations, all these things that I work on, and they involve competitors, they involve some information exchange, and they all pose antitrust risk.
Well, this is Holden. I'm going to pick up where Kristen left off. I'm really happy to be here today talking about these issues in what I'm just going to call a blockbuster year for healthcare antitrust and particularly issues that affect healthcare systems. As you likely know or live every day, if you work with or for a healthcare system has a truly unique relationship with payers, and the payer contracting process can be much more involved than it is for other types of providers like a community-based physician group, et cetera. And some systems are payers if they have an integrated plan. So in the payer contracting space, which in antitrust is often where the rubber meets the road, in healthcare, right? It's, how much leverage does a provider have to increase rates with a payer or negotiate better terms, et cetera. It's that kind of balance that the antitrust enforcers and plaintiffs are often looking at. If there are more moving parts in that payer provider relationship and negotiation process, it's just going to be more more complex and will demand more attention with respect to antitrust issues. In addition, a system is often the largest employer in a community, and sometimes the largest consumer of a particular product or service. And increasingly, as we're going to discuss a little later, the antitrust risk involves the buy side or the employer side these days of a healthcare provider's business. So any employment related or procurement related issues, may be more pronounced with respect to antitrust risk for a healthcare system as opposed to another kind of provider. But, most of all, systems can often be, hubs in a community for contacts with other providers and, vendors and, consultants and third parties that have connections to other competitors, et cetera. And there's a steady drumbeat of communications with, community-based competitors, doctors that have privileges or PSAs with the system, et cetera. And frankly, other system competitors are oftentimes partners in initiatives, et cetera. So anytime that you have touch points among competitors, there's antitrust risk. And so because the most serious antitrust violations often involve competitor interactions, this is a real serious risk frontier for health systems. All right, Kristen, we're moving on to slide 7, antitrust developments, what system counsel need to know now.
Perfect. And I think we can head right into our first topic, which is the Memorandum of Understanding the Office of Inspector General of HHS entered into back in December with the Department of Justice Antitrust Division. And it's focused on coordinated efforts in information sharing, enforcement activity, and training between the two agencies. As a healthcare lawyer, we know that the OIG is actively focused on investigations of potential fraud, waste, and abuse. There's the OIG hotline. They run a self-disclosure protocol. And so they're actively gathering a lot of information on providers. And under this memorandum, Holden, it sounds like there will be some information sharing between the agencies, and would love your perspective, given the focus on antitrust, on how you think this information will flow and how it might be used by the DOJ if they are doing something kind of, semi-routine with a healthcare provider on the OIG side.
So this memorandum of understanding between HHS and DOJ is one of a number of these very similar memorandums that have been executed with non-antitrust government agencies. So for instance, DOJ Antitrust Division has a memorandum of understanding with, I believe, USDA, the Department of Labor, all kinds of other agencies that where they want to build a bridge to take advantage of investigations and, pools of information that these agencies have that may contain information relevant to antitrust violations. So I would predict that this HHS memorandum of understanding, which involves a formalized process to share data, investigation materials, to train up the HHS investigators about how to spot antitrust violations or, like language or conduct that might be related to an antitrust violation, and also have just sort of regular cadence of meetings and dedicated teams on both the DOJ side and the HHS side. All of that is going to, I think, lead to a greater number of antitrust investigations in the healthcare space. We know for a fact that there have been times where serious antitrust violations have been uncovered in the context of a straight up healthcare regulatory investigation. So this is not a new path. This is a well-worn path between these different agencies. So I think that this is part of a pattern, across many different sectors and industries to try and make sure that the antitrust investigatory teams have the benefit of the investigatory work that these other agencies are doing. So I would think that from a practical perspective, if you're counsel to a health system and you are producing large quantities of information or going in and meeting with HHS, et cetera, about a pure regulatory issue, you should do a little due diligence on the antitrust side to make sure that you have an understanding of what the implications are of handing over this information from an antitrust point of view. So, Kristen, you and I were earlier talking about a situation where maybe someone was looking into, an arrangement between a system and a physician group or something like that. And there was, some audit related material that showed what the financial relationships were. If for some reason that was going to also reveal that there was improper information sharing or price fixing, et cetera, you want to know about those antitrust implications before you start producing information to HHS. So it's another risk frontier to think about when you are interfacing with HHS.
Absolutely. Thanks so much for the clarity there, Holden. And I mean, I think there's no such thing as a routine self-disclosure interaction necessarily. If you have a complicated arrangement with joint ventures or co-management arrangements, agreements that could contain restrictive covenants, different financial terms, the government's going to get all that and potentially share it with the antitrust division, it sounds like. So be forewarned.
Kristen, I've advanced to slide 9.
Perfect. Another compliance topic. In March, the Department of Justice issued new compliance program guidance. And I'm sure you all know that corporate compliance is a key factor for prosecutors and judges under the Justice Manual, the U.S. Sentencing Guidelines, and the Department of Justice Criminal Division policies. And as a healthcare lawyer, I've helped organizations develop and implement compliance programs, focusing in on those OIG 7 core elements. And a lot of systems are putting great resources and personnel and time and training towards their compliance programs. But, it strikes me that, even those that may have a perfect healthcare program may be falling short of where they need to be if there's really inadequate focus on antitrust risk. And Holden, I was hoping you could speak to kind of what an adequate antitrust program that meets those kind of core criteria we've outlined here consists of.
Sure. So I just want to, add to what Kristen said. It is true that you can have been the most compliance-minded healthcare provider or healthcare, in-house counsel for many, many years, to be completely on top of your game on the healthcare regulatory side and still have no idea about the antitrust laws or how they apply to you. It is true that the OIG guidance did not traditionally include antitrust as an element of a comprehensive program, but the Department of Justice and the Federal Trade Commission now do have an expectation that sophisticated providers, in particular, like health systems, will have an antitrust compliance program. So one of the sort of takeaways from the guidance that DOJ issued in 2023, it just underscores what the core requirements are for any competent program with respect to antitrust in addition to everything else. Is it well designed? Is it applied earnestly and in good faith? Does it actually work? The new areas of focus that were announced in March of 2023 were, they want to see there be some incentives and consequences for employees for violating an antitrust policy, or rewards for following the antitrust policy. There was also a special warning about how it will be perceived on the enforcement side if you allow employees to use disappearing message or encrypted messaging functions to conduct business communications. The implication is that if your employees are using Signal or WhatsApp with disappearing messages to talk about business, then you are not going to be able to adequately audit business communications for compliance purposes, and also that you will be frustrating any eventual investigation into into your conduct. So those were the two sort of like new areas of focus in the DOJ compliance guidance. But getting back to basics, a lot of you may already have a compliance program in place for antitrust. It still does not surprise me that, how many sophisticated providers have not gotten to the point of implementing a program. What I always say is that you can get a quality compliance program in place without a lot of expense or time or, diversion of resources. What you need, the basic components are a policy that's tailored to your organization and that's designed by Antitrust Counsel. So this should not be an off-the-shelf document that you grab from the internet from some organization that bears no resemblance to yours. You should be able to demonstrate to any enforcer who is sort of kicking the tires on your compliance program that this was designed by competent antitrust counsel and is specifically tailored to your organization. You should implement regular, broad, and targeted training across the organization. I have found that it is incredibly helpful to have, a high-level training for your board and all of your business leaders, particularly in departments where there are sort of antitrust risk frontiers. So people rarely think of it, but you definitely want your HR leaders to be educated about your antitrust policy and avoiding risk and reporting and detecting potential violations. Your procurement team, your managed care team for sure. Marketing activity has been the focus of Department of Justice Antitrust Division enforcement activity, business development, and obviously your legal team. And usually this is, if it's well designed and if people understand how the training and the policy applies to their day-to-day, and if they understand how it protects not just the organization, but them as individuals, it's usually, they are very grateful. So I think the most effective way to pitch a training program is we as an organization want to give you, our individual team members, the tools to protect yourself and the organization and to enable us to stay on the right side of the line with respect to the antitrust laws and manage this risk effectively. There should also be sort of an auditing function to test whether the program is working and whether it's current in light of new guidance. I have a practice of, once a year flying to clients and sitting down with the chief compliance officer, the chief legal officer, going through the policy, making tweaks, figuring out if our training is adequate, is it, up to date with the guidance. And so we develop a nice paper trail. We develop a nice paper trail in case anybody asks about, our compliance commitment in this area.
And I think, Holden, that leads to the next question on the ROI to having a compliance program on the antitrust front.
So I think that the ROI of antitrust compliance is incredibly high. If you're in a position of having to sell this to your leadership in your organization, these are the points that I would make. It protects your organization and your individual employees from not just civil liability, but criminal liability. If you get tagged with a felony antitrust violation as a health system or any kind of health provider, there's a very serious risk of debarment from Medicare and Medicaid. And it can affect, even outside of that, can affect a lot of your payer relationships. So for a lot of organizations, that debarment would be sort of a game over circumstance. So because the consequences are so serious, taking some basic measures to protect yourself and your team members, there's no question that it's prudent. The other thing that I have found over the years that's most valuable is that when you educate your employees about antitrust compliance and you make it mandatory under a policy or a protocol that they escalate these issues to the legal department as soon as possible, you really allow for detection of potential violations at a point where you can actually make a difference. Sometimes this is just shutting down an initiative or a communication or a pattern and practice of conduct that people don't realize is unlawful, sometimes it's being able to create a record that, hey, let's say another provider had invited one of your employees to enter into an improper arrangement. You can create a paper trail showing that you refused that invitation, which can be worth its weight in gold if there is eventually some investigation in the space where you're operating. And also, the DOJ Antitrust Division has a very unique leniency program. So if you become aware of some improper collusive conduct, for instance, involving your employees, and you are the first person to report it to the Department of Justice Antitrust Division, you can get a grant of leniency under certain circumstances, which means that you will not be prosecuted. So this is a huge carrot that the antitrust laws provide to people to come in, to self-report, and to be protected from prosecution, subject to certain conditions and ongoing cooperation. An antitrust compliance policy is a tool for deterrence, right, of teams that may not be aware of what the antitrust laws are and how they apply in healthcare. Maybe they've sat through training, they're just not, it doesn't hit them that they could go to jail for 10 years, for these types of violations, et cetera. So again, it's an opportunity to deter violations, and also, connect people with really their self-interest in avoiding violations as well, in addition to just doing the right thing and obeying the policy. And again, it'll just serve the organization well in the event that there's ever an investigation or an enforcement action to sort of establish credibility with the Department of Justice, FTC, or state AG, and to show that you were really acting in good faith trying to comply with these laws. It will also make a difference, again, at sentencing, if you really get tangled up in a criminal investigation, or, it may allow you to escape a criminal proceeding altogether and have the, enforcers stay on the civil side of, pursue something civilly. So
That's great.
Huge ROI here.
Yeah, that sounds like an amazing ROI, and it's good to have the carrots and the sticks. And I know we have some examples of what not to do later on. And I think on our healthcare compliance trainings, a lot of times seeing the way this actually plays out is really illuminating, especially for people in their specific roles, and help avoid traps. I guess moving to the next big development we wanted to cover. In February, the FTC, it was the DOJ in February, followed by the FTC in July, withdrew some really long-standing guidance on antitrust enforcement policy in healthcare, including their joint 1993 and 1996 statements and their statement regarding ACO participation in the MSSP program from 2011. And given how long this guidance has been in place, I had a dusty binder on my desk for years. I imagine that much, or even most of the antitrust advice and the memos that health systems have received and are maybe relying on cite to this guidance, and it's now gone. So I just wanted to talk with you, Holden, about what does this mean?
So, to be honest with you, it seems like this sort of cataclysmic, major development, but really this was DOJ and FTC bringing their published guidance in line with how they were already looking at enforcement in healthcare. So to some extent, it's like they were coming clean about what they were actually doing. They were basically sending a message to healthcare providers saying, hey, we had these frameworks in place for a really long time, right? But the healthcare world in 1996 looks very different from the healthcare world in 2023, right? We're talking about, brick phones with battery packs versus iPhones, or, like horse and buggy and Tesla. And so they're basically saying that we don't think that healthcare as a market is susceptible to this kind of standardized treatment, safety zones, et cetera. And so we're going to look at everything on a case by case basis, which, to be honest with you, they were doing anyway. But just before we move on from this slide, I will just say that one thing I think is a good idea to do is to think about arrangements that you have that may rely on these healthcare statements and the safety zones, et cetera. So, if you received antitrust advice anytime between now and, going back to 1996, there's a good chance that antitrust counsel relied on these statements. And it probably is a good idea to sort of, for certain arrangements that may have evolved and so forth, to just make sure that they would still pass muster today, and that you're not relying on the, things like safety zones and the frameworks that are articulated in these older statements. So probably a good idea to, dust off some of this stuff and make sure that you are comfortable based on the,
current
DOJ, FTC enforcement frameworks.
Those are
Kristen,
great
I'm
points.
going to move on.
Yeah, to your point, I think things have changed a lot. I mean, for example, when I first started working with health systems to stand up clinically integrated networks, we relied a lot on antitrust counsel and these statements and some of the advisory opinions that cited to the statements. I mean, the whole kind of idea of clinical integration, I think, is tied up in them. And, we were getting questions about the necessity of using an EHR to participate in this, program. And, I think there's a thought that, wow, we've got all this interoperability and technology today, we're golden, but today's market's more complicated. So, do you have any specific advice for those who may have set up like clinically integrated networks or relied on, even the advisory opinions? I know we've chatted, and even the most recent advisory opinion on a SEN is 10 years old at this point. So anything specific to address on that point before we move on?
So I think that I would just say that, again, it's always good to set up, a regular review of the collaborative arrangements that you have with, for instance, a clinically integrated network between a system and, non-employed community-based physicians. Usually the justification for a clinically integrated network is that the efficiency, quality, access, benefits outweigh any harm to competition that flow from any joint contracting that you may be doing. Making sure that, you can still articulate that balance, is weighs in favor of those pro-competitive benefits, and that, you could defend the arrangement based on, our current sense of how competition in healthcare works, et cetera, is probably a good idea. So again, it's just that dusting off and making sure that everything you have in place would pass muster under current guidance. Yeah. I think it's the thing to do.
Yeah, so never was a bright line rule for when you can move to joint contracting, but always a good idea to be focused. I guess moving on, the next item on our list is FTC policy statement, and this is more of maybe an academic or a political thing, but I know that it's been getting a lot of press that the FTC came out with statements regarding the scope of unfair methods of competition under Section 5 of the FTC Act, which may be consistent with the Act. I don't know. They seem to reach pretty far, beyond what they normally do under the Sherman Act and the Clayton Act. And I've heard there may be some challenges. Is there anything you want to speak to about sort of this posture that came out from the FTC in November?
Well, there's a lot and very little to say about this. This is a law that's been on the books for a very long time, and it's always been sort of a catch-all for the FTC to pursue violations that they can, describe as being unfair methods of competition, and that really runs the gamut. And so in November of 2022, they published this, policy statement that said, hey, you want to know what this very vague category of conduct, includes? Here is a, 200-page document or whatever it is that explains it. And, I will just say that the shift here is that, or the clarification that the FTC made in the statement is just to say, like, hey, you should know that we consider conduct that maybe hasn't ripened into a violation to be something that we are permitted to go after under the FTC Act. We don't have to necessarily show that this has lessened current competition. We can just show that it may tend to lessen future competition, or it may tend to bring about harms that the antitrust laws were designed to prevent, even if they have not yet, resulted in those harms. So, I think that this just opens up what I'll just say the penumbra, an enforcement penumbra around what we traditionally think of as antitrust violations. And I think that the current FTC leadership is very committed to using this as a tool, and we've seen it. So again, I think this goes to making sure that your advice is current. Here's a way that the goalposts in a way have sort of moved on the field a little bit. I think the FTC is emboldened to be able to use this law. It's civil, it's not criminal. They're just going to use this law to, try and change behavior and conduct, et cetera. But it's still, it's still something under which they can pursue investigations and pursue conduct remedies in particular. I'm moving to the slide 14, Kristen.
All right, perfect. So now something a little more technical. I think a lot of us think about in a trust when we have a big transaction that meets the HSR or Hart-Scott-Rodino threshold. And I think it was June that there were some proposals to change the rule, the form, the instructions around HSR filings with comments due next month, September 27th. Do you have any kind of takeaways or practical guidance related to this, proposed change, Holden?
Sure. So I think the headline here is that if you have lived through a Hart-Scott-Rodino filing on another transaction, your next Hart-Scott-Rodino reportable transaction is likely to look very different. So what the FTC and DOJ did this summer is they proposed a revamp of the form and instructions for filing HSR. That sounds pretty like, what's the big deal? It's just form and instructions. But it really totally transforms what you need to provide to the FTC DOJ in any transaction that's subject to HSR, even one that frankly has no, particular hair on it from an antitrust perspective. So for every deal that's HSR reportable, I'll just say that the deal value right now for being HSR reportable is $111.4 million. So this really only affects sizable deals, but these days a physician practice transaction can reach that level. It's going to take you much, much longer. Even the FTC has said that they think it's going to expand by a factor of 4 with respect to the number of hours, and obviously then the amount of legal expense that is attached to making an HSR filing. It's significantly more burdensome with respect to what you're required to provide, including longitude and latitude coordinates for all of the places where you provide services, for instance. There's a document retention obligation. So that means you have to have a document hold put in place on all of your electronic resources, individual devices, et cetera. And also they are requiring the parties to expressly proclaim the motivations for doing the deal. So you never really before had to, expressly under penalty of perjury as part of the HSR form, explain why you were doing this. And so I think that, there's also an obligation to link up your narrative about why you're doing the deal to documents in your normal course files or documents that you are, submitting in connection with the HSR. And those things, I think they're going to look for them to line up. So, I think a lot of times we see people who post facto are able to identify a great pro-competitive reason for doing the deal. And I think that that's often legitimate, but they forgot to articulate that in their normal course documents as they were, making presentations to the board or to their business development team, et cetera, et cetera. And so I think it's going to be really important for people to, and this has always been the case, but it's going to be really important for people in this new HSR environment. If you're doing a big deal, make sure that these pro-competitive motivations for doing a deal and entering into the transaction are clear on the face of your document, because they are going to tell the tale of the deal in this form, which is, as you know, a dossier of information that the regulators are going to review in the first instance to decide whether they're going to issue a second request or eventually even potentially challenge the deal. The other thing I just want to mention quickly is that if you are in a state where you have a certificate of public advantage law, that would, purportedly, insulate a deal from federal antitrust enforcement. There's a really interesting litigation going on right now between HCA and LCMC down in New Orleans and the FTC about whether a COPA insulates parties from HSR reporting obligations. So that's one to watch. That's going to be a very interesting litigation. Kristen, I've moved ahead to slide 15.
Yeah, again, on the topic of transactions, this is the merger guidance we got from the FTC DOJ in July. New horizontal merger guidance. It supplanted the withdrawn vertical merger guidance. I know that comments are due next month. I saw that 20 organizations, including the American Hospital Association, requested an extension of the comment period for at least 60 more days, saying the agencies took 15 months to come out with the merger guidelines. They needed a little more time to comment. Was hoping, Holden, that you could focus on, based on the guidelines and what you're seeing in the enforcement, or at least the review of these deals, what are the key focus areas? What does this mean for vertical mergers? Maybe speak a little bit to cross-market mergers. Are they addressed? And, is there a new focus that we really need to hone in on here?
Sure. And I also want to make a point about the HSR rules as well. Just like the merger guidelines, these are proposed. So both the new HSR rules and the new merger guidelines are both just in their proposed state, and the agencies are, receiving comments, and they may be revised before they go into effect. So the HSR rules may very well be revised by the time they get implemented. I think the expectation now is that they will be in place by the end of 2023. The new merger guidelines, the FTC and DOJ did a lot of listening sessions and, received a lot of input before they even drafted their proposed guidelines. So they may feel that they are sort of well on their way to having these finalized. But it is true that we're in an active comment period. I will say that, for health systems, how do these general guidelines affect health systems? I think healthcare is one place where we've seen a lot of focus on the impact of vertical mergers. So that's, like if you're a health system and you have your own integrated health plan and you're acquiring a, large primary care practice, like they're not only going to look at the effect on competition on the provider side, but maybe on the payer side too. If you're going to be then able to, for instance, deprive other payers of access to that primary care practice that you're acquiring, et cetera. They also lower the thresholds for finding market concentration. And this would be relevant in a horizontal deal. So for instance, if before you got advice from an antitrust lawyer that if you acquired the system that, in the next county, and that, your market shares would really only be, 35%. That didn't look too bad under the merger guidelines. The new merger guidelines have lowered the threshold for market concentration. So where, previously maybe a 35% share in general acute care would not have, caused someone any concern, now it may get another look from FTC, DOJ, or whoever's looking at the transaction if the new guidelines are applied. But again, just like some other guidance that we've talked about, the FTC DOJ have really said, like, look, these merger guidelines are just letting you know, we're being transparent about how we are already looking at things. So this is not a change in the law. The courts still say yes or no to, challenges brought by FTC DOJ under these laws. This is just FTC DOJ kind of laying out their hand and telling people how it is that they, what they think the correct framework is for looking at transactions and arrangements.
And Holden,
so, yeah.
Yeah, I just asking quickly, this goes to cross-market mergers, but just in generally, it seems like there's some different economic theories. It's not just market concentration in a local market necessarily. Could you speak to what they're focused on in terms of employees, the labor market, what it does there, and then, other theories of like employers who are trying to, need to have hospitals in their network. Just, are there other things that we should be focused on that maybe were on the periphery before?
So we do have, now in the books, some significant long-term investigations that were undertaken with respect to cross-market mergers. Health systems who were many, many states apart from each other, or maybe just contiguous states. So there is a theory of what we call, cross-market harm, where you have employers who need both of those systems, like a national employer, for instance, or a regional employer who need both of those systems, and where one of the systems is a must-have can result in, for instance, increasing the rates or improving the terms, or requiring that an employer take both systems as opposed to just one. I mean, there are any number of ways that the regulators have framed up these cross-market theories of harm, but it is something to pay attention to. So again, if 5 years ago you got advice about a potential acquisition of another system in another state, and someone said, like, no problem, we all agree there's no overlap, horizontal overlap, now I think you do need to add in that analysis about cross-market harm. We haven't really seen any federal enforcement relating to cross-market harm necesserily.
But
we
that,
definitely have seen.
Yeah, to our next topic. State review. Would you be able to address, in the context of mergers, but also acquisitions? I think, in my practice, I see this in physician roll-ups in hospitals that are acquiring big physician groups. States are looking and, imposing filing requirements and waiting periods. And it's kind of hard to keep up with all the states that are into the action nowadays. Could you kind of hit the highlights for us, Holden?
Sure. This is incredibly, I will just say, complex, fact intensive. There is no, sort of like easy way to figure out whether your transaction is covered by these, really different state statutes. But what we've seen in just the past, 5 years is a real proliferation of state statutes where either a health authority or the attorney general is requiring a pre-close filing from the parties so that there's an opportunity to review and assess and oftentimes impose conditions on or potentially challenge a transaction. So in 3 huge states, California, New York, Illinois, they all have new laws. New York's came online August 1. California is coming online April 1st of next year. Illinois is coming online January 1 of next year. Connecticut and Massachusetts have long had, they're going on, I think, 10 years. Each of them had a statute, and they have revenue thresholds that you have to meet. So really the states are saying, like, we really only care about hearing from you if you have what we're going to call a material transaction. But those materiality thresholds, so like, let's say there was a threshold a few years ago that was $25 million. We don't need to hear from you unless your deal is worth, or one party has $25 million in revenue. I mean, that was a big deal. Now that we have experienced a trend towards consolidation and bigger practices and bigger consolidated providers, a lot more deals are likely to hit that $25 million, just example of a threshold. So I think that folks who operate in these states, Washington, Oregon, California, Massachusetts, Connecticut, Illinois, Minnesota, Nevada, New York, need to be aware of how these statutes apply to them. And even if you've been aware of this, just kind of like maybe, revisit them a little bit, because you could have been doing business in, for instance, Massachusetts without having to think about this for a long time. And now, like maybe you need to make sure that how, now that you're doing deals with bigger dollar values attached to them, like, do you need to be thinking about this?
Yeah,
So
and
anyway.
super quickly, I know we've talked about it in the context of serial transactions as well. So kind of knowing what's in the pipeline and figuring out your analysis with the states and the feds is important, I'd say.
Yes, because I think that what motivates a lot of these states, and what I think motivated the creation of a model statute that a lot of these states use and a lot of states are considering right now, is the idea that healthcare antitrust is a local concern, that the consolidation is a local concern. It's often happening below the radar of the HSR threshold, so the deals are not being reviewed or caught by the feds, and that the states have something invested in reviewing these transactions themselves.
That's right. And
so
there's
I'm going to move to slide.
Public information available. And then I think the next topic, interlocking directorates. I mean, for health systems, typically their affiliates, we talk about Copperworld, we talk about who's on the directors for purposes of having a taxable subsidiary of a tax-exempt hospital. But I know this comes into play, Holden, when you've got a board seat on a competitor or joint venture. Is there anything you wanted to highlight quickly on this slide?
Yes. So what we are seeing, including just in the past week, is a huge ramp up of enforcement by the FTC and DOJ relating to interlocking directorates. And I'm just going to say there are two flavors of interlocking directorates. One of them is where one competitor has a board seat on another competitor's board of directors, and they meet the technical thresholds articulated in Section 8 of the Clayton Act. Again, this is like a materiality threshold. Basically, the Clayton Act Section 8 says we only care about interlocking directorates where the parties are sufficiently big and have a sufficiently large amount of what they call competitive sales, meaning revenue in a competitive area, meaning same service line, same geographic area, et cetera. Otherwise, it's not actionable under Clayton Act Section 8. But there's another flavor, and this goes to the FTC Act, which we just talked about a few slides ago. And that's where the FTC has said, like, hey, we care about catching this conduct, even if it doesn't technically violate an antitrust law, even if we think it's just going to be harmful in some way, or maybe harmful down the road. And the FTC has, indicated a willingness to look at interlocking directorates and say, like, hey, we don't like that competitor A is sitting on competitor B board because they see all the payer contracts, they see the marketing strategy, they see the expansion plans, et cetera. And we know that that kind of information exchange, that competitively sensitive information exchange between competitors, is not good for competition. So we're going to go after it. So again, the takeaway here before we move to the next slide is just to, it's a good idea to review your board representation on entities that are competitors or potential competitors of your system in some way.
Thank you. And now on to criminal monopolization, some of the scary stuff, Holden.
So I'm just going to quickly, because we're running a little bit out of time for these last 3 points. So I'm going to kind of, lump these together a little bit. As I mentioned, it's really only in the past 3 or so years that we have seen the Department of Justice Antitrust Division pursue healthcare providers using the criminal side of the Sherman Act. So the Sherman Act is the main federal antitrust law. It can be pursued civilly. It can also be pursued criminally. For corporations, it is a $100 million fine. For individuals, it's up to 10 years in prison and $1 million fine per count. So, serious consequences. And we really did not see healthcare providers being pursued criminally until April of 2020, basically, after many, I would say, many decades of the DOJ declining to pursue actions criminally. But here we are. So not only do we have a DOJ willing to pursue healthcare providers criminally, but we also have them branching out into new theories of harm. And so this year they brought their first criminal monopolization case in 40 years. This is a case that took place in like the, like highway repair space out west in, Montana or Wyoming. So not healthcare at all. But this is a situation that resulted in a criminal enforcement action where a participant with arguably a monopoly share in a market where there was really only one other competitor all they had to do was invite that competitor to take actions that would result in an agreement, not to compete, for purposes of maintaining each of their large, market shares. Here it was just an invitation. It was not accepted. The person who received the invitation called the enforcers. It resulted in wiretaps. There was no agreement, but it was still an attempted monopolization charge that led to a criminal enforcement action. So my point here is just that if you are health system, and as we said before, you can often have a very, very large footprint in your market. There should now be, an understanding that large market share, whether it is by acquisition or just by natural accident because you're in a rural area or whatever, that carries a little bit of extra risk with it, and maybe the need to, consider how your conduct would be perceived, how your motivations would be perceived. Kristen, I'm just going to move on to slide 10 and just say that, in addition to monopolization, there's also the classic criminal activity that is, when it's undertaken by a healthcare provider, has been pursued by DOJ in the past few years. Agreements not to compete between competitors and potential competitors are historically the most serious antitrust violations. And that's what we're seeing draw the attention of regulators and enforcers right now in the healthcare space. These are agreements that are per se unlawful. This is not like a justifiable non-compete that is reasonably drawn and attached to a legitimate JV that you have with someone. This is sort of like the bare, naked agreement not to compete with no justification. These are per se unlawful. These are violations where even if you didn't know it was illegal, even if you did not intend to do anything illegal, even if you can't really point to how competition was injured, none of that is really necessarily relevant to an enforcer or to a court. So DOJ has remained focused on, wage fixing and no poach agreements. We've seen several of those in several different healthcare spaces. Even if they're very short-lived, just a couple of months, just a couple of providers. And even if they were driven by some kind of interest in stability, saw a lot of people claiming that COVID should be looked at as a justification for these agreements not to recruit or hire each other's employees, or agreements on what you're going to pay. Those are not valid or relevant excuses from the DOJ's point of view. Market allocation has also been a focus of criminal enforcement. I think this is a particular risk in healthcare where people perceive themselves to be in a specialty. They perceive themselves to geography, and it makes kind of common sense for them sometimes to think that they should approach a competitor and say, hey, wouldn't it make sense if, you stayed out of this? I'll stay in Hearts, I will stay in this metropolitan area if you stay in this metropolitan area. Let's not create inefficiencies by trying to compete with each other. That is
And for
also
the
conduct
audience,
that,
yeah, we have
excuse
some
me?
slides that show text messages and examples from of what not to do in this communication, Holden.
Sure. So, I think one place where people kind of should focus their training with employees to avoid this very serious kind of violation is to, a lot of people don't understand the kind of agreement that can lead to a criminal violation. It can be an informal handshake agreement. It doesn't need to be in writing. It can be, something that you would characterize as like mutual respect, or having this kind of common sense basis, like during COVID, not stealing each other's employees, etc. It can often happen very informally, as Kristen said, over text message. It can be with just potential competitors, not even somebody who's actively competing with you, but somebody who could. And one of the main things that I see is that if employees believe that, quote unquote, everybody does it, they believe that somehow that's going to insulate their conduct. That is the most dangerous fallacy right there. The main message, and I'll get to the sample text messages in a moment, the main message to build into your antitrust policy ultimately is to just, make it off limits for your employees to discuss competitively sensitive information in contexts where they are present with other competitors, industry associations, JVs, due diligence, day-to-day communications with your friends and colleagues at other, provider organizations, et cetera. Communications with third parties that might pass on competitively sensitive information, like the status of your payer negotiations, where you're going to be opening up facilities, what you're going to be paying people, et cetera. We chose one example ripped from a very recent healthcare criminal indictment, which just lays out, this is how it can happen. On one day, one person texts another saying, like, how much are you paying LPNs? I just heard somebody was paying $30 an hour. I was hoping it wasn't you. Just that paragraph that you see on the screen right now is really enough to pursue a multi-year criminal antitrust investigation and to subject not only the company, but also the individual to really serious consequences. As Kristen said, we came up with these, texts that also show how easily these agreements can be can come about. Here is like just between two doctors who may play golf together. Hope all is well with you. Nice to hear from you. Thanks for the referral. Hey, I just want to let you know that our office manager may be looking to leave. Sorry to hear that. Yes, I don't want to lose him. I know that your system is opening a new office and you're probably staffing up. Please don't hire him. It would make things difficult for my practice. At that moment in time, if your doctor who is receiving this text knows to escalate this conduct to your legal department, you can stop this in its tracks before there is any more damaging communication created. You can reach out to the physician who is issuing the invitation to formally express that you are not accepting that invitation. Just managing the risk around a simple exchange like this can be the difference between getting into and avoiding a criminal investigation if this conduct ever came to light. Same thing, it doesn't take more than 5 texts to hatch a potential agreement not to hire or nurses or to what you're going to pay them. Same thing. This is just between 2 physicians in the same system talking about conversations that they'd like to have with their colleagues at a competing system. If someone in this conversation knows that this needs to be escalated to legal, you can easily manage the risk before this turns into a a communication with a competitor that could be construed as unlawful. Kristen, I'm going to skip to the takeaways because it looks like we have just a few seconds, if you're okay with that.
Yeah, perfect. Take us home, Holden.
So, what are the priority things that we think that that you should do? Number one, best ROI is to implement a compliance program or update your compliance program, including policy and training. Number two, make sure you have a pipeline to good information about the changes in state and federal antitrust law and what the guidance is. So make sure that you are on the McGuireWoods antitrust healthcare alerter list, or give us a call if you would like to get an orientation to what's happening now in your area. Review your existing relationships for those interlocking directorates, for any information exchange that may be happening that you want to put some firewalls around, or any other aspects of arrangements that could pose antitrust risk. Consider strategies to implement if the non-compete rule that has been proposed by the Federal Trade Commission, which we didn't quite get to today, goes into effect, or there are similar developments in your state that would affect your ability to put non-compete clauses into your employment contracts. And bring your transaction teams into the tent with respect to antitrust to make sure that it's a factor in their business planning. I can't tell you the number of times that a very skilled business development team has hatched a plan to acquire or partner with, et cetera, another provider organization. They've gotten so far down the road, they don't bring in antitrust as a consideration until very late in the game. And it turns out that that is a major factor that probably should have changed the course of their business planning. So those are our top tips today. And let me just check the questions.
Yeah, I think we have a couple. The webinar will be available after we've recorded it if you've gotten pulled into something else or couldn't stay a couple of minutes late. Please feel free to reach out. Holden and I both have included our contact information. If you have any questions or interested in receiving any of our antitrust or healthcare alerters, or just want to talk through an issue kind of informally, or set up a CLE or training for your system. Thank you all so much for joining. Holden, did you see anything you can address on the fly?
Yes, there are a couple questions about whether the slides are going to be distributed, and my impression is that they are, because they are, form the basis of our CLE material for today. And then I have another question about state action exemption in areas like Medicare and Medicaid. Super interesting question that I will try and take on offline.
Fantastic. Well, again, thank you, Holden, for being part of this webinar. This was very informative, very pragmatic. You're very approachable as an antitrust partner, and you speak healthcare clearly. So we appreciate you taking your time. And thanks to everyone who has joined us today for our webinar on practical advice for antitrust for Health System Council.